Stephen Phillips.
Thank you very much, Mr. Deputy Speaker. I wasn't. I'm very grateful for being called in this debate, and I should apologise for the fact that during the early part, I think, of the speech preceding the Honourable Lady who's just spoken, in fact, I absented myself to go and have a sandwich, not having had any lunch. So I wasn't expecting you to call me quite this early in the debate, but anyway, there we are. This is obviously an important debate, and I wanted to speak not necessarily for the full time that's available to me, just in relation to the sentencing aspects of the Green Paper in particular. And I wanted to do that, of course, from my perspective as I think one of the two sitting recorders in the House. I think, I'm not sure whether the other is intending to speak, but it seemed to me important that I did that in circumstances where sentencing has got itself into a bit of a mess in this country, at least in England and Wales, and has become exceptionally complicated for the judiciary. And for that reason, it seems that the proposals which the government is putting forward in this bill are proposals which are important not just from the perspective of breaking the cycle, as the consultation document was concerned, but also from the perspective of the judiciary and the operation of the criminal courts in effectively sentencing criminals and meting out due punishment for the offences of which they have been convicted by a jury. The starting point, of course, with sentencing is the fact that in 2003 a Criminal Justice Act was placed before the House and indeed passed by the previous government, which was amended on a number of occasions thereafter, but which was in fact a complete minefield, which was so complicated that in one case the Court of Appeal commented that the relevant provisions were labyrinthine, in another they were described as a legislative morass. And in a case called CPS in South East Surrey Youth Court, the Court of Appeal said, so yet again, the courts are faced with a sample of the deeply confusing provisions of the Criminal Justice Act 2003 and the satellite statutory instruments to which it is giving stuttering birth. The most inviting course for this court to follow would be for its members, having shaken their heads in despair, to hold up their hands and say the holy grail of rational interpretation is impossible to find. And I have to tell the House that the position in which the courts have found themselves in relation to sentencing during the last decade has been utterly intolerable. Judges have had to spend considerably more time than they ought to be doing when they ought to be trying cases, preparing sentences, giving reasons above and beyond those which they were previously obliged to give, and in fact giving reasons which probably are immaterial for either the victims of crime or indeed those who are on the receiving end of the sentence to hear. And so the simplification of this part of sentencing by the current bill, assuming that it becomes law, is much to be welcomed. But I wanted to go further because it is important, and I hope that the Lord Chancellor will listen to what I say in this regard and to what others have said, including the Sentencing Guidelines Council, and I think the Bar Council and the Law Society, because what we actually need, and I hope that we will see it during the course of this Parliament, is a consolidating statute which brings together sentencing for the entirety of the criminal law. And it is only then, not only that the process will become simpler, not only then that judges will be able to sentence in a way that they are satisfied they are unlikely to be appealed to the Court of Appeal unless they've got it very wrong, but people will know precisely what sort of sentences the courts are likely to hand down for the same sorts of offence. And that will, in due course, lend considerable support from the public, I imagine, to the criminal justice system itself. I wanted to say a few words about legal aid. My honourable friend, the member for Maidstone and the Weald, I think spoke for many of us when she expressed the concerns that we have about the removal of legal aid in relation to some of the areas which are proposed by the Department, and I hope that those will be explored in a great deal of detail, particularly given the comments of my right honourable friend, the Lord Chancellor, during the course of his intervention on her. I hope those will be explored in a great deal of detail during the Bill Committee stage, because I want this bill to come back with a report from the committee that it is satisfied that those who are the most vulnerable in our society will continue to have access to justice in precisely the same way that those who are able to buy it have access to justice. And I say that, of course, from the perspective of one who, as a lawyer, considers access to justice to be extraordinarily important. And I am concerned, as I know she is, about those particular provisions and about the way in which they might discriminate against some of the most vulnerable in our society. That said, I've no doubt that the bill will be amended in committee. I've no doubt that the government will listen. I hope it will. I'm not sure that this bill has got absolutely everything right, but it is a step in the right direction, particularly as regards the burgeoning legal aid budget, under which we pay in this country 8 times as much as the French taxpayer pays for our citizens who are entitled to legal aid to receive access to justice. Now, it is not suggested that there is some desert in France where nobody has access to justice, and it must therefore be possible to reduce the costs of legal aid, as indeed the Shadow Secretary of State, the Shadow Lord Chancellor, said last year when he accepted that if Labour was in power, they too would have to be making cuts to the legal aid budget. And it is a matter of regret and shame that rather than coming to the House and telling the House where he would be making those cuts, he made a series of...
No, he didn't.
Well, it's quite extraordinary to hear at least one honourable member on the other side of the House saying he spelt it out, because I listened to the entirety of his speech, and I didn't hear anything spelt out at all. I heard nothing spelt out at all, so... Well, I'll tell you... There's a shadow minister on the front bench, so perhaps he could tell us now where Labour would make the cuts in the legal aid budget.
There's a publication called Hansard, which the honourable gentleman might wish to read tomorrow, and he will see in that, and I'll repeat it now, though I feel I'm taking backbench members of time, that the proposals in the March consultation 2010 put forward by the then Labour government, which have not been taken forward by this government, would more than compensate for the cuts being made in social welfare legal aid. Go and have a look at that consultation, and the honourable gentleman will see.
Well, I will go and have a look, and I'm sure that the front bench on this side of the House will also go and have a look, and we'll be able to see during the course of the wind-ups whether that's accepted as being correct. For my own part, I rather doubt that it will...
You don't even know. Not a clue.
I'm grateful, Mr Deputy Speaker. I didn't really want to get particularly into the legal aid aspects of this bill. I've expressed my own concerns. I'm sure those are being listened to on the front bench. And I am concerned that we've had opposition from the other side of this House, at least without any detail being spelt out as to where they would make the cuts which they accept have to be made in the legal aid budget.